NMetzel. The nature, purpose, and function of criminal law. May the police officers be subjected to prosecution in both state and federal court. As the videotape begins, it shows that King rose from the ground and charged toward Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground. From the 18th to the 30th second on the videotape, King attempted to rise, but Powell and Wind each struck him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's leg. At the 55th second, Powell struck King on the chest and King rolled over and lay prone. At that point, the officers stepped back and observed King for about 10 seconds. At 1 minute 5 seconds, on the tape, Bersenio in the district court's words stomped on King's upper back or neck. King's body writhed in response. At 1 minute and 7 seconds, Powell and Wind again began to strike King with a series of baton blows, and Wind kicked him in the upper thoracic or cervical area 6 times until minute and 26 seconds. At about a minute and 29 seconds, King put his hands behind his back and was handcuffed. Learning objectives. To define a crime, provide examples of criminal behavior, and distinguish between civil and criminal law. To explain the difference between criminal law and criminal procedure. To discuss the difference between felonies and misdemeanors and the difference between mala ins and mala prohibita. List and describe the various sources of criminal law. Introduction. Criminal law is the foundation of the criminal justice system. The law defines the conduct that may lead to an arrest by the police, trial before the courts, and incarceration in prison. When we think about the criminal law, we typically focus on offenses such as rape, robbery, and murder. States, however, condemn a range of acts in their criminal codes, some of which may surprise you. In Alabama, it is a criminal offense to promote or engage in a wrestling match with a bear or to train a bear to fight in such a match. With such a match. A Florida law states that it is unlawful to possess any ignited tobacco product. In an elevator, Rhode Island declares that an individual shall be imprisoned for 7 years who voluntarily engages in duel with a dangerous weapon or who challenges an individual to a duel. In Wyoming, you can be arrested for skiing while being impaired by alcohol, or for opening and failing to close a gate, an offense that crosses a private road or river. You can find criminal law on the books in various states punishing activities such as playing dominoes on Sunday, feeding an alcoholic beverage to a moose, cursing on a miniature golf course, making love in a car, or performing a wedding ceremony when either the bride or groom is drunk. In Louisiana, you risk being sentenced to 10 years in prison for stealing an alligator, whether dead or alive, valued at $1,000. The nature of criminal law. Are these common characteristics of acts that are labeled as crimes? How do we define a crime? The easy answer is that crime is whatever the law declares to be a criminal offense and punishes with a penalty. The difficulty with the approach is that not all criminal convictions result in a fine or imprisonment. Rather than punishing a defendant, the judge may merely warn him or her not to repeat the criminal act. Most commentators stress that the important feature of a crime is that it is an act that is officially condemned by is officially condemned imprisonment. Rather than punishing defendant, the judge may merely warn him or her not to repeat the criminal act. Most commentators stress that the important feature of a crime is that it is an act officially condemned by the community and carries a sense of shame and humiliation. Professor Henry M. Hart Jr. defines crime as conduct which, if shown to have taken place, will result the format and solemn pronouncement and moral condemnation of the community. The central point of Professor Hart's definition is that a crime is subject to formal condemnation by a judge and jury representing the people in a court of law. That distinguishes a crime form acts most people would find objectionable, that typically are not subject to state prosecution and official punishment. We might, for instance, criticize someone who cheats on his or her spouse, but we generally leave the solution to the individuals involved. Other matters are left to institutions to settle. Schools generally discipline students who cheat or dispute classes, but this rarely results in a criminal charge. Professional baseball, basketball, football leagues have their own private procedure for disciplining players. Most states leave the decision whether to recycle trash to the individual and look to peer pressure for enforced obligation. Criminal and civil law. How does criminal law differ from civil law? Civil law is that branch of law that protects the individual rather than the public interest. A legal action for civil wrong is brought by an individual rather than a state prosecutor. You may sue a mechanic who breaches a contract to repair your car, or bring an action against a landlord who fails to adequately heat your apartment. The injury is primarily you as an individual, and there is relatively little harm to society. A mechanic who intentionally misleads and harms a number of innocent consumers, however, may find himself or herself charged with criminal fraud. Civil and criminal actions are characterized by different legal procedures. For instance, conviction of a crime requires a high standard of proof beyond a reasonable doubt, although responsibility for a civil wrong is established by a much lower standard of proof by a preponderance of the evidence, or roughly 51% certainty. The high standard of proof in criminal cases reflects the fact that a criminal conviction may result in a loss of liberty and significant damage to an individual's reputation and standing in the community. The famous 18th century English jurist William Blackstone summarizes the distinction between civil and criminal law by observing that civil injuries are infringement of the civil rights which belong to individuals. Public wrongs or crimes are a breach and violation of the public rights and duties due to the whole community. In its social aggregate capacity, Blackstone illustrates this difference by pointing out that society has little interest in whether someone sues a neighbor or emerges victorious in a land dispute. On the other hand, society has a substantial investment in the arrest, prosecution, and conviction of individuals responsible for espionage, murder, and robbery. The difference between a civil and criminal action is not always clear, particularly with regard to an action for a tort, which is an injury to a person or to his or her property. Consider the drunken driver who turns a red light and hits your car. The driver may be sued in tort for negligently damaging you and your property, as well as criminally prosecuted for reckless driving. The purpose of the civil action is to compensate you with money for the damage of your car and for your physical and emotional injuries you have suffered. In contrast, a criminal action punishes a driver for endangering society. Civil liability is based on a preponderance of the evidence standard, while a criminal conviction carries a possible loss of liberty and is based on the higher standard of guilt beyond reasonable doubt. You may recall that former football star O.J. Simpson was acquitted of murdering Nicole Brown Simpson and Ron Goldman, but was later found guilty of wrongful death in a civil court in ordering to compensate the victims' families in the amount $33.5 million. The distinction between criminal and civil law provide immensely significant for Kansas inmate Leroy Hendricks. Hendricks was about to be released after serving 10 years in prison for molesting two 13-year-old boys. This is only the latest episode of Hendricks' almost 30-year history of indecent exposure and molestation of young children. Hendricks freely conceded that when not confined, the only way to control his sexual urge was to die. Upon learning that Hendricks was about to be released, Kansas authorities invoked the Sexually Violent Predator Act of 1994, which authorized the institutional confinement of individuals who, due to a mental abnormality or a personality disorder, are likely to engage in predatory acts of sexual violence. Following a hearing, a jury found Hendricks to be a sexual predator. The U.S. Supreme Court ruled that Hendricks' continued commitment was a civil rather than a criminal penalty, and that Hendricks was not being unconstitutionally punished twice for the same criminal act of molestation. The court explained that the purpose of the commitment procedure was to detain and to treat Hendricks in order to prevent him from harming others in the future rather than to punish him. Do you think that decision of the U.S. Supreme Court makes sense? The purpose of criminal law. We have seen that criminal law primarily protects the interests of society, and civil law protects the interests of the individual. The primary purpose or function of criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of criminal law is to establish a system of prohibitions, penalties, and correctional measures to deal with the conduct that unjustifiably and inexcusably causes or threatens harm to those individual or public interests for which state protection is appropriate. The New York Criminal Code sets out the basic purposes of criminal law as follows. Harm. To prohibit conduct that unjustifiably or inexcusably causes or threatens substantial harm to individuals as well as to society. Warning. To warn people both of conduct that is subject to criminal punishment and or severity of the punishment. Definition. To define the act and intent that is required for each offense. Seriousness. To distinguish between serious and minor offenses and to assign the appropriate punishments. Punishment. To impose punishments that satisfy the demands for revenge, rehabilitation, and deterrence of future crimes. Victims. To ensure that the victim, the victim's family, and the community interests are represented at trial and in imposing punishments. The next step is to understand the characteristics of a criminal act. The principles of criminal law. The study of substantive criminal law involves an analysis of the definition of specific crimes, specific part, and of the general principles that apply to all crimes. General parts such as the defense of insanity in our study. We will first interview the general part of criminal law and then look at the specific offenses. Substantive criminal law is distinguished from criminal procedure. Criminal procedure involves the study of legal standards governing and detection, investigation, and prosecution of crime, and includes areas such as interrogations, search and seizure, wiretapping, and the trial process. Criminal procedure is concerned with how the law is enforced. Criminal law involves what law is enforced. Professors Jerome Hall and Wade R. Lefebvre identify the basic principles that compose the general part of criminal law. Think of the general part of the criminal law as the building blocks that are used to conduct specific offenses such as rape, murder, and robbery. Criminal act. A crime involves an act or failure to act. You cannot be punished for bad thoughts. A criminal act is called actus reus. Criminal intent. A crime requires a criminal intent or mens rea. Criminal punishment is ordinarily directed at individuals who intentionally, knowingly, recklessly, or negligently harm other individuals or property. Concurrence. The criminal act and criminal intent must coexist or accompany one another. The defendant's act must cause the harm required to criminal guilt. Death in the case of a homicide, and the burning of a home or other structure in the case of arson. Responsibility. Individuals must receive reasonable notice of the acts that are criminals, so as to make a decision to obey or to violate the law. In other words, the required criminal act and criminal intent must be clearly stated in statute. The concept is captured by the Latin phrase nullum crimen sine lege, nulla poena sine lege. No crime without law, no punishment without law. Defenses. Criminal guilt is not imposed on an individual who is able to demonstrate that his or her criminal act is justified, benefits society, or excuse the individual suffered from a disability that prevented him or her from forming a criminal intent. We now turn to specific parts of the criminal law to understand the various types of acts that are punished as crimes. Categories of crime: felonies and misdemeanors. There are a number of approaches to categorizing crimes. The most significant distinction is between a felony and a misdemeanor. A crime punishable by death or by imprisonment for more than 1 year is a felony. Misdemeanors are crimes punishable by less than a year in prison. Note that whether a conviction is for a felony or for a misdemeanor is determined by the punishment provided in the statute under which an individual is convicted rather than by the actual punishment imposed. Many states subdivide felonies and misdemeanors into several classes or degrees to distinguish between the seriousness of criminal act. Capital felonies are crimes subject either to death penalty or to life in prison in states that do not have the death penalty. The term gross misdemeanor is used in some states to refer to crimes subject to between 6 and 12 months in prison, whereas other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations or infractions. These tend to be acts that cause only modest social harm and carry fines. These offenses are considered so minor the imprisonment is prohibited. This includes a violation of traffic regulations. Florida classifies offenses as felonies, misdemeanors, or non-criminal violations. Non-criminal violations are primarily punishable by a fine or a forfeiture of property. The following list shows the categories of felonies and misdemeanors and the maximum punishment generally allowable under Florida law. Non-criminal Florida law. Capital felony, death or life imprisonment without parole. Life felony, life in prison, and a $15,000 fine. Felony in the first degree, 30 years in prison and a $10,000 fine. Felony in the second degree, 15 years in prison and a $10,000 fine. Felony in the third degree, 5 years in prison and a $5,000 fine. Misdemeanor in the first degree, 1 year in prison and a $1,000 fine. Misdemeanor in second degree, 60 days in prison and a $500 fine. The severity of the punishment imposed is based on the seriousness of the particular offense. Florida, for example, punishes a second-degree felony the recruitment of an individual who, for prostitution, knowing that force, fraud, and coercion will be used to cause the person to engage in prostitution. The same act punished the first-degree felony in the event the person recruited is under 14 years. old, or if death results. Mala in se and mala prohibita. Another approach to classify crime by moral turpitude, evil. Mala in se crimes are considered inherently evil and would be evil if they prohibited by law, even if not prohibited by law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibita offenses are not inherently evil and are considered only wrong because they are prohibited by a statute. This includes offenses ranging from tax evasion or carrying a concealed weapon, leaving the scene of an accident and being drunk and disorderly in public. Why should we be concerned with classification schemes? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to the armed forces or joining the police, and prevent you from adopting a child or receiving various forms of federal assistance. In some states, a convicted felon is still prohibited from voting, even following release. The distinction between mala in se and mala prohibita is also important. For instance, the law provides that individuals convicted of a crime or of moral turpitude made to be deported from the United States. There are a number of other classification schemes. The law originally categorizes as infamous those crimes that were considered to be deserving of shame or disgrace. Individuals convicted of infamous offenses such as treason, betrayal of the nation, or offenses involving dishonesty were historically prohibited from appearing as witness at a trial. Subject matter. The textbook is organized in accordance with the subject matter of crimes, the scheme that is followed in most state criminal codes. There is a disagreement, however, concerning the classification of some crimes. Robbery, for instance, involves the theft of property as well as the threat of infliction of harm to the victim. There is a debate about whether it should be considered a crime against property or against the person. Similar issues arise in regard to burglary. Subject matter offenses in descending order to seriousness as follows. Crimes against the state: treason, sedition, terrorism. Crimes against the person: homicide, murder, manslaughter. Crimes against the person: sexual offenses and other crimes: rape, assault, battery, false imprisonment, kidnapping. Crimes against habitation: burglary, arson, trespassing. Crimes against property: larceny, embezzlement, false pretenses, receiving stolen property, robbery, fraud. Crimes against public order: disorderly conduct, riot. Crimes against the administration of justice: obstruction of justice, perjury, bribery. Crimes against public morals: prostitution, obscenity. The book also covers the general part of criminal law, including the constitutional limits of criminal law, sentencing, criminal acts, criminal intent, the scope of criminal liability, and defenses to criminal liability. Sources of criminal law. We now have covered the various categories of criminal law. The next questions to consider are these. What are the sources of criminal law? How do we find the requirements of criminal law? There are a number of sources of criminal law in the United States. English and American criminal law. These are English and American judge-made laws and English acts parliament. State criminal codes. Every state has a comprehensive written set of laws on crime and punishment. Municipal ordinances. Cities, towns, and counties are typically authorized to enact local criminal laws, generally of minor nature. These laws regulate the city's streets, sidewalks, and buildings and concern areas such as traffic, littering, disorderly conduct, and domestic animals. Federal Criminal Code. The U.S. government has jurisdiction to enact criminal laws that are based on the federal government's constitutional powers, such as the regulation of interstate commerce. State and federal constitutions. The U.S. Constitution defines treason and together with state constitutions establishes limits on the power of government to enact criminal laws. A criminal statute for instance, may not interfere with freedom or expression or religion. International treaties. International treaties signed by the United States establish crimes such as genocide, torture, and war crimes. These treaties, in turn, form the basis of federal criminal laws punishing acts such as genocide. Americans are involved. These cases are prosecuted in the U.S. courts. Judicial decisions. Judges write decisions explaining the meaning of criminal law and determining whether criminal law meets the requirements of state and federal constitutions. Judges typically rely on precedent and the decision of other courts in similar cases. At the point, we turn our attention to the common law origins of American criminal law and the state criminal codes. The common law. The English common law of the foundation of American criminal law, the origins of the common law can be traced to the Norman conquest of England in 1066. The Norman king, William the Conqueror, was determined to provide a uniform law for England and sent royal judges throughout the country to settle disputes in accordance with the common customs and practices of the country. The principles that composed this common law began to be written down in 1300. In an effort to record, the judge made rules that should be used to decide future cases. By 1600, a number of common law crimes had been developed, including arson, burglary, larceny, manslaughter, mayhem, rape, robbery, sodomy, and suicide. These were followed by criminal attempt, conspiracy, blasphemy, forgery, sedition, and solicitation. On occasion, the king and the crimes of the false pretenses and embezzlement. The distinctive characteristic of the common law is that it is for the most part the product of the decisions of judges in actual cases. The English civil and criminal common law was transported to the new American colonies and formed the foundation of the colonial legal system that in turn was adopted by the 13 original states following American Revolution. The English common law was also recognized by each state subsequently admitted to the Union. The only exception was Louisiana, which followed the French Napoleonic Code until 1805, when it embraced the common law. The state criminal codes. The state in the 19th century began to adopt comprehensive written criminal codes. This movement was based on the belief that in a democracy, the people should have the opportunity to know the law. Judges in the common law occasionally punished an individual for an act that had never before been subjected to prosecution. A defendant in a Pennsylvania case was convicted of making obscene phone calls despite the absence of a previous prosecution for this offense. The court explained that the common law is sufficiently broad to punish, although there may be no exact precedent, any act which directly injures or tends to injure the public. There was the additional argument that the power to make laws should reside in the elected legislative representatives of the people rather than the unelected judges. As Americans began to express a sense of independence, there was also a strong reaction against being so clearly connected to the English common law tradition, which was thought to have limited relevance to the challenges facing America. As early as 1812, the U.S. Supreme Court proclaimed that the federal courts were required to follow the law established by Congress and were not authorized to apply the common law. States were somewhat slower than the federal government to abandon the common law. In a Maine case in 1821, the accused was found guilty of dropping the dead body of a child into a river. The defendant was convicted even though there was no statute making this a crime. The court explained that the good morals and decency all forbid this act. State legislators reacted against these types of decisions and began to abandon the common law in the mid-19th century. The Indiana Indiana revised statutes of 1852, for example, proclaim that crimes and misdemeanors shall be defined and punishment fixed by statutes of this state, and not otherwise. Some states remain common law states, meaning that the common law may be applied where the state legislature has not adopted a law in a particular area. The Florida Criminal Code states that the common law of England in relation to crimes, or except so far as the same relates to the mode and degrees of punishment, shall be of full force in the state where there is no existing provision by statute on the subject. Florida law further provides that where there is no statute, an offense shall be punished by fine or imprisonment, but that the fine shall not exceed $500, nor the term of imprisonment 12 months. Missouri and Arizona are also examples of common law states. These states' criminal codes, like that of Florida, contain a reception statute that provides the states receive the common law as an unwritten part of their criminal law. California, on the other hand, is an example of code jurisdiction. The California Criminal Code provides that no act or omission in criminal or punishable except as prescribed or authorized by this code. Ohio and Utah are also code jurisdiction states. The Utah Criminal Code states that common law crimes are abolished and no conduct is a crime unless made so by this code or ordinance. Professor LeVay observes that the courts in common law states that have recognized a number of crimes that are not part of their criminal codes, including conspiracy, attempt, solicitation, uttering gross obscenities in public, keeping a house of prostitution, cruelly killing a horse, public inebriation, and false imprisonment. You also should keep in mind that the common law continues to play a role in the law of code jurisdiction states. Most state statutes are based on the common law, and courts frequently consult the common law to determine the meaning of terms in statutes. And well-known California case of Keeler and versus Superior Court, the California Supreme Court looked on the common law and determined that an 1850 state law prohibiting the killing of a human being did not cover the murder of a fetus. The California state legislature then amended the murder state to punish the unlawful killing of a human being or fetus. Most important, our entire approach to criminal trials reflects the common law's commitment to protecting the rights of the individual in the criminal justice process. State police power. Are these limits on a state's authority to pass criminal laws? Could a state declare that it is a crime to possess fireworks on July 4th? State governments possess a broad power to promote the public health, safety, and welfare of the residents of the state. The wide-ranging police power includes the duty to protect the well-being and tranquility of the community and to prohibit acts or things reasonably thought to bring evil or harm to its people. An example of the far-reaching nature of the state police power is the U.S. Supreme Court's upholding of the right of a village to prohibit more than two unrelated people from occupying a single home. The Supreme Court proclaimed that the police power includes the right to lay out zones where family values, youth values, and blessings of quiet seclusion and clean air makes the areas a sanctuary for people. State legislators in formulating and content of criminal codes have been profoundly influenced by the Model Penal Code. The Model Penal Code. People from other countries often ask how students can study the criminal law of the United States, a country with 50 states and a federal government. The fact that there is a significant degree of agreement in the definition of crimes in state codes is due to a large extent of the Model Penal Code. In 1962, an American Law Institute, a private group of lawyers, judges, and scholars, concluded after several years of study that despite our common law heritage, state criminal statutes radically varied in their definition of crimes and were difficult and understood and poorly organized. The ALI argued that the quality of justice should not depend on the state in which an individual was facing trial and issued a multi-volume set of model criminal laws. The proposed official draft of the Model Penal Code. The Model Penal Code is purely advisory and is intended to encourage all 50 states to adopt a single uniform approach to the criminal law. The statutes are accompanied by a commentary and explains how the Model Penal Code differs from the existing state statutes. Roughly 37 states have adopted some of the provisions of the Model Penal Code. Although no state has adopted every single model law, the states that most closely follow the code are New Jersey, New York, Pennsylvania, and Oregon. As you read this book, you may find it interesting to compare the Model Penal Code to the common law and to state statutes. The book primarily discusses the state law. It is important to remember that we also have a federal system of criminal law in the United States. Federal statutes. The United States has a federal system of government. The states granted various powers to the federal government that are set forth in the U.S. Constitution. This includes the power of regulate interstate commerce, to declare war, to provide for the national defense, to coin money, to collect taxes, to operate the post office, and to regulate immigration. The Congress is entitled to make all laws which shall be necessary and proper for fulfilling these responsibilities. The states retain those powers that are not specifically granted to the federal government. The 10th Amendment to the Constitution states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. The Constitution specifically authorizes Congress to punish the counterfeiting of U.S. currency, piracy, and felonies committed on the high seas and crimes against the law of nations, as well as to make rules concerning the conduct of warfare. These criminal provisions are to be enforced by a single Supreme Court and by additional courts established by Congress. The Federal Criminal Code compiles the criminal laws adopted by the U.S. Congress. This includes laws punishing acts such as tax evasion, mail and immigration fraud, bribery in obtaining a government contract, and the knowing manufacture of detective military equipment. The Supremacy Clause of the U.S. Constitution provides that the federal law is superior to state law within those areas that are the preserve of the national government. This is termed to preemption doctrine. In 2012, the Supreme Court held that federal immigration law preempted several sections of an Arizona statute directed at undocumented individuals. Several recent court decisions have held that federal criminal laws have unconditionally encroached on areas reserved for the state governments. This reflects a trend toward limiting the federal power to enact criminal laws. For instance, the U.S. government within the Interstate Commerce Clause has interpreted its power to regulate interstate commerce as providing the authority to criminally punish harmful acts that involve the movement of goods or individual across state lines. An obvious example of the interstate transportation of stolen automobiles. In the past few years, the U.S. Supreme Court has ruled several of these federal laws unconstitutional based on the fact that the activities did not clearly affect interstate commerce or involve Congress violated by the Constitution by adopting the Gun-Free School Zone Acts in 1990. Which made it a crime to have a gun in a local school zone. The fact that the gun may have been transported across the state lines was too indirect a connection with interstate commerce on which to base federal jurisdiction. In 2000, the Supreme Court also ruled unconstitutional the U.S. government's prosecution of an individual in Indiana who was alleged to have set fire to a private residence. The federal law made it a crime to maliciously damage or destroy by means of fire or an explosive any building used in interstate or foreign commerce or in an activity affecting the interstate of foreign commerce. The Supreme Court ruled that there must be a direct connection between a building and the interstate commerce and rejected the government's contention that it is sufficient that a building is constructed of supplies or serviced by electricity that moved across the lines, or that the owner's insurance payments are mailed to the company located by another state. Justice Ruth Bader Ginsburg explained that this would mean that every building in the land would fall within the reach of federal laws on arson, trespass, and burglary. In 2006, in Oregon v. Gonzalez, the Supreme Court held that U.S. Attorney General John Ashcroft lacked the authority to prevent Oregon physicians acting under the state's death with dignity law from prescribing lethal drugs to terminally ill patients who are within 6 months of dying. The sharing of power between the federal and state governments is termed dual sovereignty. An interesting aspect of dual sovereignty is that it is constitutionally permissible to prosecute a defendant for the same act at both the state and federal levels, so long as the criminal charges slightly differ. This double prosecution does not constitute double jeopardy. You might recall in 1991, the Rodney King, an African American, was dropped by the Los Angeles police. King resisted and eventually was subdued, wrestled to the ground, beaten and handcuffed by 4 officers. The officers were acquitted by an all-Caucasian jury in a state court in Simi Valley, California. Leading to the widespread protests and disorder in Los Angeles, the federal government responded by bringing the 4 officers to trial for violating King's civil rights to be arrested in a reasonable fashion. 2 officers were convicted and sentenced to 30 months in federal prison, and 2 were acquitted. Later in the chapter, you will be asked to decide whether this double prosecution is fair. We have seen that the state and federal government possesses the power to enact criminal laws. The federal power is restricted by the provisions of the U.S. Constitution that define the limits on governmental power. Constitutional limitations. The U.S. Constitution and individual state constitutions establish limits and standards for the criminal law. The U.S. Constitution, as we shall see in Chapter 2, requires the following. A state or local may not regulate the area between the reserved time and federal government. A federal law may not be encroach upon state power. A law may infringe upon the fundamental civil and political rights of individuals only in compelling circumstances. A law must be clearly written and provide notice to citizens and to the police of the conduct that is prohibited. A law must be non-discriminatory and may not impose cruel and unusual punishment. A law also may not be retroactive and punish acts that were not crimes at the time that they were committed. The ability of legislators to enact criminal laws is also limited by public opinion. The American constitutional system is a democracy. Politicians are fully aware that they must face elections and that they may be removed from the office in the event that they support an unpopular law. As we learned during the unsuccessful effort to ban the sale of alcohol during the Prohibition era in the early 20th century, the government will experience difficulties in imposing an unpopular law on the public. Crime in the news. In 1996, California became one of the 23 states to authorize the use of marijuana for medical purposes. The other states are Alaska, Arizona, Colorado, Connecticut, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, Oregon, Rhode Island, Vermont, and Washington, and the same applies in the District of Columbia. Maryland exempts medical marijuana users from jail sentences. California voters passed California voters passed Proposition 215, the Compassionate Use Act of 1996, which is intended to ensure that seriously ill residents of California are able to obtain marijuana. The act provides an exemption from criminal prosecution for doctors who, in turn, may authorize patients and primary caregivers to possess or cultivate marijuana for medical purposes. The California legislation is directly at odds with the Federal Controlled Substance Act, which declares it a crime to manufacture it, distribute or possess marijuana. There are more than 100,000 medical marijuana users in California, and roughly 0.1% of the population uses medical marijuana in the states that collect information on medical marijuana users. Angel Rich and Diane Monson are two California residents who suffer from severe medical disabilities. Their doctors have found that marijuana is the only drug that is able to alleviate their pain and suffering. Rach's doctor goes so far as to claim that Angel's pain is so intense that she might die if deprived of marijuana. Monson cultivates her own marijuana, and Rach relies on two caregivers who provide her with California-grown marijuana at no cost. On August 15, 2000, agents from the Federal Drug Enforcement Administration, DEA, raided Munson's home and destroyed all 6 of her marijuana plants. The DEA agents disregarded objections from the Butte County Sheriff's Department and the local California District Attorney's Office that Munson's possession of marijuana was perfectly legal. Monson and Raish, along with several doctors and patients, refused to accept the destruction of the marijuana plants and asked the U.S. Supreme Court to rule on the constitutionality of the federal government's refusal to exempt medical marijuana users from criminal prosecution and punishment. The case was supported by California Medical Association of Leukemia and Lymphoma Society. Raish suffers from severe chronic pain stemming from fibromyalgia, endometriosis, scoliosis, uterine fibroid tumors, rotator cuff syndrome, inoperable brain tumor, seizures, life-threatening wasting syndrome, and constant nausea. She also experiences extreme chemical sensitivities that result in violent allergic reactions to virtually every pharmaceutical drug. Rach is confined to a wheelchair before reluctantly deciding to smoke marijuana, a decision that led her to enjoying a fairly normal life. A doctor recommended that Monson use marijuana to treat severe chronic back pain and spasms. She alleges that marijuana alleviates the pain that she describes as comparable to an uncontrollable cramp. Monson claims that the other drugs have proven ineffective or resulted in nausea and create the risk of severe injuries to her kidneys and liver. That marijuana reportedly reduces the frequency of Monson's spasms and enables her to continue to work. The U.S. Supreme Court, in Gonzalez v. Raish in 2005, held that the federal prohibition on the possession of marijuana would be undermined by exempting marijuana possession in California and the other states from federal criminal enforcement. The Supreme Court explained that the cultivation of marijuana under California's medical marijuana law, although clearly a local activity, frustrated the federal government's effort to control the shipment of marijuana across the state lines, because medical marijuana is inevitably would find its way into interstate commerce, increase the nationwide supply, and drive down the price of illegal drugs. There was also a risk that completely healthy individuals in California would manage to be fraudulently certified by a doctor to be in need of medical marijuana. 3 of the 9 Supreme Court judges dissented from the majority opinion. Justice Sandra Day O'Connor observed that the majority judgment stifles an express choice by some states concerned for the lives and liberties of other people to regulate medical marijuana differently. Following the decision, Angel Raish urged the federal government to have some compassion compassion and have some heart and not to use taxpayer dollars to come in and lock us up. We are using this medicine because it is saving our lives. She asked why the federal government was trying to kill her. Opponents of the medical marijuana defend the Supreme Court's decision and explain that individuals should look to traditional medical treatment rather than being misled into thinking that marijuana is an effective therapy. They also argue that the marijuana is a highly addictive drug that could lead individuals to experiment with even more harmful narcotics. The Obama administration initially did not enforce federal marijuana laws against individuals in medical marijuana states. In 2011, the Department of Justice announced that although individuals could grow and use small amounts of medical marijuana, that the DOJ would criminally prosecute growers of more than 100 plants and individuals involved in the commercial marketing and sale of marijuana. In 2013, the Obama administration reversed course and announced that it would not prosecute individuals in medical marijuana states unless the individuals threatened certain federal law enforcement interests. This included the distribution of marijuana to minors, providing revenue to criminal enterprise, diversion of marijuana to states where marijuana remains illegal, and the possession of use of marijuana on federal property. In 2014, Congress adopted a law prohibiting the Justice Department from using resources to prevent states from implementing their own state laws that authorize the use, distribution, possession, or cultivation of medical marijuana. Where do you stand on the medical marijuana controversy? Of course, the Democratic will of the majority is subject to constitutional limitations. A classic example is the Supreme Court's rulings of popular federal statutes prohibiting and punishing flag burning and desecration compose an unconstitutional violation of freedom of speech. Consider the following factual scenario that is taken from the U.S. Supreme Court's description of the events surrounding the beating of Rodney King. You decide 1.1. On the evening of March 2nd, 1991, Rodney King and two of his friends sat in King's wife's car in Altadena, California, a city in Los Angeles County, and drank malt liquor for a number of hours. Then, with King driving, they left Altadena via a major freeway. King was intoxicated. California Highway Patrol, CHP, officers observed King's car traveling at a speed they estimated to be in excess of 100 miles per hour. The officers followed King with red lights and sirens activated and ordered him by loudspeaker to pull over, but he continued to drive. The Highway Patrol officers called on the radio for help. Units of the Los Angeles Police Department joined in pursuit. One of them manned by petitioner Lawrence Powell and his trainee Timothy Wind. The officers are all Caucasian. King is African American. King later explained that he fled because he feared that he would be returned to prison after having been released 4 months earlier following a year spent behind bars for robbery. King left the freeway and after a chase of about 8 miles stopped at an entrance to a recreation area. The officers ordered King and his two passengers to exit the car and to assume a felony-prone position, that is, to lie on their stomachs with legs spread and arms behind their backs. King's two friends complied. King, too, got out of the car but did not lie down. Petitioner Stacy Kuhn arrived at once, followed the Ted Brasino and Roland Solano. All were officers of the Los Angeles Police Department, and as Sergeant Kuhn took charge. The officers again ordered King to assume the felony-prone position. King got on his hands and knees but did not lie down. Officers Powell, Wind, Brinso, and Solano tried to force King down, but King resisted and became combative, so the officers retreated. Kuhn then fired taser darts designed to stun a combative suspect into King. The events that occurred next were captured on videotape by a bystander. As videotape begins, it shows that King rose from the ground and charged toward Officer Powell. Powell took a step and used his baton to strike King on the side of his head. King fell to the ground. From the 18th To the 30th second on the videotape, King attempted to rise, but Powell and Wind each struck him with their batons to prevent him from doing so. From the 35th to the 51st second, Powell administered repeated blows to King's lower extremities. One of the blows fractured King's left leg. At the 55th second, Powell struck King on the chest and King rolled over and lay prone. At this point, the officers stepped back and observed King for about 10 seconds. Powell began to reach out for his handcuffs. At the sentencing phase, the district court found that Powell no longer perceived King to be a threat at this point. At 1 minute, 5 seconds on the videotape, Briseno and district court's words stomped on King's upper back or neck. King's body writhed in response. At 1 minute and 7 seconds, Powell and Wind again began to strike King with a series of baton blows, and Wind kicked him in the upper thoracic or cervical area 6 times until 1 minute and 26. At about 1 minute and 29, King put his hands behind his back and was handcuffed. Powell radioed for an ambulance. He sent 2 messages over a communications network to the other officers and said, "Oops, and I haven't beaten anyone this bad in a long time." Kuhn sent a message to the police station that said, "Unit just had a big time use of force, tased and beat the suspect of CHP pursuit big time." King was taken to a hospital where he was treated for a fractured leg, multiple facial fractures, and numerous bruises and contusions. Learning that King worked at Dodger Stadium, Powell said to the King, "We played a little ball tonight, didn't we, Rodney? We played a little ball. We played a little hardball tonight. We hit quite a few home runs. Yes, we played a little ball, and you lost, and we won." Kuhn, Powell, Briseno, and Wind were tried in California State Court on charges of assault with a deadly weapon and excessive use of force by a police officer. The officers were acquitted of all the charges, with the exception of one assault charge against Powell that resulted in a hung jury. The jury was composed of the 10 Caucasians, 1 Hispanic, and 1 Asian American. The verdicts touched off widespread rioting in Los Angeles. More than 40 people were killed in the riots. More than 2,000 were injured, and nearly $1 billion in property was destroyed. Los Angeles Mayor Tom Bradley declared that there appears to be a dangerous trend of racially motivated incidents running through at least some segments of the police department. And President George H.W. Bush announced in May that the verdict had left him with a deep sense of personal frustration and anger, and that he was ordering the Justice Department to initiate a prosecution against the officers. On August 4th, 1992, a federal grand jury indicted the 4 officers, charging them with violating King's constitutional rights under color of law. Powell, Briseno, and Wind were charged with willful use of unreasonable force in arresting King. Kuhn was charged with willfully permitting the other officers to use unreasonable force during the arrest. After a trial in U.S. District Court for the Central District of California, the jury convicted Kuhn and Powell but acquitted Wind and Briseno. Kuhn and Powell were sentenced to 30 months in prison. This jury was composed of 9 Caucasians, 2 African Americans, and 1 Hispanic. King later won a $3.8 million verdict from the city of Los Angeles. He used some of the money to establish a rap records business. The issue to consider is whether officers King and Powell may be prosecuted and acquitted in California State Court and then prosecuted in federal court. This seems to violate the prohibition on double jeopardy in the 5th Amendment to the U.S. Constitution, which states that individuals shall not be twice put in jeopardy of life and or of limb. Double jeopardy means that an individual should not be prosecuted more than once for the same offense without this protection. The government could subject people to a series of trials in an effort to obtain a conviction. It may surprise you to learn that judges have held that the dual sovereignty doctrine permits the U.S. government to prosecute an individual under federal law who has been acquitted on the state level. The theory is that the state's federal governments are completely different entities, and that the state government is primarily concerned with punishing police officers and with protecting residents against physical attack, while the federal government is concerned with safeguarding the civil liberties of all Americans. Each of these entities provides a check on the other to ensure fairness for citizens. The evidence introduced in two prosecutions to establish the police officer's guilt in the King case was virtually identical, and the federal prosecution likely was brought in response to political pressure. On the other hand, the federal government historically has acted to prevent unfair verdicts, such as the acquittal of members of the Ku Klux Klan charged with killing civil rights working during the 1960s. Do you believe that this is fair to subject to the Los Angeles police officers to the expense and the emotional stress of two trials? As the Attorney General to the United States, would you have advised President George H.W. Bush to bring federal charges against the officers following their acquittal by a California jury? Chapter summary. Criminal law is the foundation of the criminal justice system. The law defines the acts that may lead to an arrest, a trial, incarceration. We typically think about crime as involving violent conduct, but in fact, a broad variety of acts are defined as crimes. Criminal law is best defined as conduct that, if shown to have taken place, will result in the formal and solemn pronouncement of the moral condemnation of the community. Civil law is distinguished from criminal law by the fact that it primarily protects the interests of the individual rather than the interests of society. The purpose of criminal law is to prohibit conduct that causes harm or threatens harm to the individual and the public interest, to warn people of the acts that are subject to criminal punishment, to define criminal acts and intent, to distinguish between serious and minor offenses, to punish offenders, and to ensure that the interests of victims and the public are represented at trial and in the punishment of offenders. In analyzing individual crimes, we will be concerned with several basic concerns that compose the general part of criminal law. A crime is composed of a concurrence between a criminal act and criminal intent, and the caution of a social harm. Individuals must be provided with notice of the acts that are criminally condemned in order to have the opportunity to obey or to violate the law. Individuals must also be given the opportunity at trial to present defenses, justifications, and excuses to a criminal charge. The criminal law distinguishes between felonies and misdemeanors. A crime punishable by a death or by imprisonment for more than 1 year is a felony. Other offenses are misdemeanors. Offenses are further divided into capital and other grades of felonies, and into gross and petty misdemeanors. A third level of offenses are violations or infractions, acts that are punishable by fines. Another approach is to classify crime in terms of moral turpitude. Mala and se crimes are considered inherently evil, and mala prohibita crimes are not inherently evil and are only considered wrong because they are prohibited by statute. Our textbook categorizes crimes in accordance with the subject matter of the offense, the scheme that is followed in the most state criminal codes. This includes crimes against the state, crimes against the person, crimes against habitation, crimes against property, crimes against public order, and crimes against the state. There are a number of sources of American criminal law. These include the common law, state and federal criminal codes, the U.S. and state constitutions, international treaties, and judicial decisions, the English common. That is it. Again, it is for student Nicole Metzel.